Myth 3. I'll always be entitled to be paid one way or the other, no matter what the contract says. My name's David Richards. I'm a solicitor at Leith Prior, specialising in construction law, and this is part of a series of video blogs that I'm doing on myths in the construction industry. And this is a very common one, perpetuated by a lot of people in the industry, including, unfortunately, some lawyers. This idea that even if the contract says one thing, if you've done the work, you'll always be entitled to be paid one way or the other. It's just a matter of finding a clever argument. Just not the case. If you have a written contract, a nice detailed written contract, perhaps a standard form contract or a bespoke document, that'll obviously dictate what money you're entitled to. And often these contracts come with provisions for dealing with extras and variations and unforeseen circumstances, and we'll also have a mechanism for dealing with prolongation costs if the project goes on for longer than could have been anticipated for reasons that aren't the contractor's fault. Doesn't have to be as detailed. Sometimes a contract can be as simple as an exchange of emails or an accepted quote. It could be verbal, it could even be part verbal and part conduct. So long as the parties are agreed on the essential terms as they see it and as the court sees it, there will usually be a contract. If for some reason a contract never comes into existence or is void, that's when the law steps in. That's where you get this clever word quantum meruit that a lot of lawyers rely on. So for example, if you've got an exchange of emails over contract terms, one party wants certain limitations to liability, or they want certain risk to be allocated in a particular way, and the other party comes back with another idea, and that exchange of emails never really resolves, there might never be a contract. And in those circumstances, yeah, there is something called quantum meruit, and all that is a clever Latin word that just means that the party will be entitled to a reasonable sum for the work that they've done. This also happens, by the way, when you've got a void contract. So, for example, if you've got a bit of legislation that makes your contract void, used to be very common under the consumer contract regulations, competition regulations. If a contract is void for any reason, sometimes quantum meruit steps in to say, well, you, the contractor, are entitled to be paid. In most cases, though, there is a contract, particularly when work has been provided. So if work's been provided, the courts say, well, if you've done the work and perhaps been paid some money, say, there's almost certainly going to be a contract. And if that contract sets out a mechanism for the price, then you're stuck with it, even if it doesn't really work. And that often happens in when the parties have been negotiating or it's a homemade contract. So for example, Grove Developments against Balfour Beatty case a couple of years ago, the parties had agreed interim payments for a project, and they hadn't thought about what's going to happen when they get if there was project overrun. Rookie mistake. They got their interim payments up to a particular point, but after that, the contract said no more interim payments. But the project was going to go on for a lot longer than that. So the contractor said, well, look, I need my money on an interim basis. I can't wait until the end because otherwise I'm going to have a cash flow difficulty. Surely there must be an implied term there. The court said no, there's no implied term. It's not necessary to have that term, so we're not going to imply it. So they were stuck to finish the project with no interim payments and wait until the end. Even worse is where, so for example, if you've got a standard form contract, let's say a JCT or something like that, and you try to agree variations on site orally, or perhaps you've got a simple contract, a letter of intent or something like that, that agrees a fixed price, and trying to agree oral variations, or even do the work without agreeing those variations. So let's say the contractor does some work that's required, that's necessary, but the client doesn't authorise that, and the client certainly doesn't agree to pay. In those circumstances, I'm afraid that if there is a no oral variations clause, which there is in JCT contracts, even if the variation has been agreed orally and not confirmed in writing, builder isn't entitled to be paid. Equally, if the contractor does the work but doesn't agree payment for that, again, not entitled to be paid. It has to be in a contract. It can, like I say, it can be simple. It can be by verbal if that's what the contract allows. It can be by exchange of emails. Like I said, depending on what the contract says, it doesn't have to be anything complicated. But if there isn't a contract for that, then you're not entitled to be paid. The myth that a lot of lawyers perpetuate, and a lot of people in the industry perpetuate, is this idea that quantum Meruit will fill in that gap. So the parties have failed to agree a payment mechanism for that variation or for that extra bit or for the prolongation costs or whatever. This idea that quantum Meruit will fill in that gap. No. The courts have said time and time again that if there is a contract in place, then this Latin doctrine, this equitable doctrine, isn't going to step in to fill those gaps. It's tough, sorry, Mr. Builder, but you should have agreed your extra cost at the time. The lesson, of course, is to always make sure when at the outset of a project you think about what's going to happen and make sure that not just the construction contract, but the costings and the payment schedule is properly thought out and properly agreed. And if there are any variations, agree some payment for that, ideally in writing, and follow the procedure that's in the contract. Don't just rely on this idea that lawyers are going to come up with a clever quantum Meruit argument, because it isn't always going to work. And that's it for this week. Thank you very much. Any questions, have a look at our website, leaseprior.co.uk. My name's David Richards. Thanks again.